Good evening, everyone, on this lovely Tuesday night. A happy Tuesday, a happy spring, and a happy Easter to everybody here. Thank you all for joining us for our next episode today. I'm Connor Fraley, the president of the Federalist Society chapter at the UNC School of Law here down in Chapel Hill, North Carolina. And I'm pleased to be hosting tonight the 9th episode in our series of Challenges to Originalism with Professor Lee Strang. Today's topic is going to be on natural law, with the challenge being that originalism is inconsistent with natural law. So thank you all for joining us. This is a particularly interesting challenge of interest to myself and to Professor Strang as well. Any questions that you have, please submit those in the Q&A, and we will do our best to get through all of those. But enough of me talking. I'm going to go ahead and introduce our speaker, and we will get rolling tonight. Professor Strang joined the faculty of the University of Toledo in 2008, got tenure in 2010, and was named the John W. Stepler Professor of Law and Values in 2015 and appointed the founding director of the Institute of American Constitutional Thought and Leadership in 2023. He was previously a visiting professor at Michigan State University College of Law. He's a graduate of the University of Iowa College of Law and Harvard Law School. He clerked for Judge Alice Batchelder on the Sixth Circuit Court of Appeals and practiced at Jenner & Bach LLP. He's been a visiting scholar at the Georgetown Center for the Constitution and a visiting fellow at the James Madison Program over at Princeton University. Professor Strang has published dozens of articles on constitutional law and interpretation, religion, and the First Amendment. His most recent book, which I have here, Originalism's Promise, a Natural Law Account of the American Constitution, which I'm sure we will talk about some today, was published by Cambridge University Press in 2019. It is the first book-length natural law justification for originalism. He's currently editing the 3rd edition of his casebook, Federal Constitutional Law, and finishing a book on the history of Catholic legal education in the United States. Professor Strang's lectured globally, is a frequent presenter at conferences, and regularly participates in debates, media commentary, and speaking engagements, including the Federalist Society as he is today. In 2022, he convened the first symposium on common good constitutionalism at Harvard. That is a lot of great things that Professor Strang is doing, and we are so glad that he's joining us today to continue this discussion. It's great to be with you tonight, and let's go ahead and get started. Is there anything that you'd like to say about this episode today before we get started with questions?
Yeah, thanks for the introduction. Thank you as well, Mr. Strang. Well, thank you for the plug for the book. The royalties are always good. And this is actually, more seriously, my favorite topic of the series, because as what you suggested, Connor, indicates, I've spent much of my professional life investigating the question. I'm at one hand an American, and being an American means, among other things, being committed to the U.S. Constitution, but also my religious tradition, my philosophical tradition is consistent with the natural law tradition. And so I wanted to see that book as an attempt to explore, if one's committed to that we have a constitution, that it's fundamentally sound, although not perfect, and that natural law is a true way of thinking about human ethics and human law, what is the way we interpret our Constitution? So Originalism's Promise was my attempt to try and do that. And so tonight's episode I actually view as an attempt to kind of navigate some of the reasons why people who believe in the natural law tradition reject originalism as the right way to interpret the Constitution, and why natural law originalists think that originalism is the right way to interpret the Constitution.
Very good. Well, I'll jump in with a basic question. The Federalist Society and legal people in general, they trend toward the nerdy side. And we have a lot of understanding of a lot of very niche topics. But even among us nerds, like, the natural law is kind of an obscure concept. So why don't you go ahead and tell us, what is natural law, or what does it mean when you talk about natural law?
Sure. Yeah, and I especially appreciate the last caveat. So when Americans or American lawyers use the label natural law, it's potentially a really broad topic, and there's lots of different conceptions of natural law. There's lots of different aspects of the tradition of natural law, especially in the West, and there's even non-Western aspects about which I know very little. So this is not a commentary on any of those. And the tradition that I'm focusing on in my work and that I'll focus on tonight, and it's not just the accident that I focus on it, but it tends to be the dominant strain, at least in the Anglo-American world, is I think genuinely the central Western philosophical tradition of reflection on what law is. It goes back to Plato and Aristotle. So for those of you, speaking of nerds who have read Aristotle, the Nicomachean Ethics, his Politics, the Eudaimonean Ethics, Aquinas, so parts of the Summa Theologica, and other writings that Aquinas had written. I think actually Aquinas is really the great kind of uniter of the tradition, where he takes different strands from different philosophical inheritance that he had and puts them together in a really elegant way. And then to the modern world. So in the 20th century, I think the most prominent natural law scholar or theorist was a Frenchman named Jacques Maritain. Man in the State was one of his more important books that people might want to read. And then, especially in the Anglo-American world, the work of John Finnis at Oxford and Notre Dame, and then Robert George at Princeton are the current pieces of scholarship that many people look to. So John Finnis's seminal book, Natural Law and Natural Rights from 1980, and Robert George's In Defense of Natural Law and Making Men Moral, I think are two sources that people might want to read. And so natural law stated in one sentence, so this is there's a lot going on in one sentence, is a belief in non-human created norms or rules or guides to conduct that are grounded in human nature and that direct or guide human actions towards human flourishing. So these aren't rules that humans have chosen. They're rules that exist because of the nature that we have. And one example might be, one of the natural law norms is to pursue leisure. And so we as humans with beings with bodies, and the bodies get tired, it makes sense that those kind of beings would have an injunction to pursue leisure in a reasonable way. As applied to law, which is our topic tonight, the natural law tradition has a particular focus on law, and it goes way back, as I said, to Aristotle, through the Romans, and through Aquinas and others in the Middle Ages. It's natural law theorists will look at a legal system, and they'll say that the things that you as a law student, the things that I as a law professor write about and teach about and think about, the constitutional provisions, the statutes, the administrative regulations, the cases, those posited legal materials, those positive legal materials that are human created, they don't exhaust the total content of a legal system. That instead, and in addition, in the natural law tradition, there are other non-human created norms that are part of the law in a jurisdiction, even if they aren't written down, so to speak, in a statute. And so this focus, this latter part where I'm focusing on natural laws applied to the legal system, that doesn't just tell us about what is in the legal system, i.e. written and unwritten legal norms, but also gives, and this I think is where the work of John Finnis is just really extraordinary, gives us explanations for the reasons why we should follow positive legal norms. Because if you think about it, it's kind of weird, right? So most Americans, when you look at polling data, think that the approval rate of Congress is like 8%. And so if you have a group of human beings of whom only 8% of their fellow citizens think they're doing a good job, why is it that we should follow, if at all, what they say, right, in the form of statutes that are ultimately approved by the president? And what the natural law tradition does is it tries to give an answer to that why question. What's the point of law? And the answer that the natural law tradition gives, at least the version that I'm understanding and describing, is that the point of law is to provide the conditions within which the members of a political community can secure the common good of that community and then their own human flourishing, their own happiness. And so natural law doesn't just tell us what law is, it also tells us what law is for. And that's one way of distinguishing this natural law reflection on the legal system from what's often put in opposition to the natural law tradition, which goes by the name of legal positivism. So legal positivism, at least in the Anglo-American tradition, has two key components. One is the source thesis, which is that all law comes from social sources. So think of the things that I mentioned earlier. Statutes come from a legislature. Administrative regulations come from administrative agencies. Cases come from courts. So all law to be law has to come from a social source. And then second is a separability or severability thesis, which is what law is, i.e. the positive law that comes from these sources, is different from what law ought to be, or where the law is moral or ethical or just. And so legal positivism says that all law is and is only the positive legal norms from those sources, regardless of how sound or unsound those positive legal norms are. And so natural law is often put in opposition to that. And I'll just circle back one more time to John Finnis's work, which has just been so influential in my own life, that one of the contributions that I think that Finnis makes from the natural law tradition's perspective is he's able to take on board what I think are the genuine insights of legal positivist scholars like H.L.A. Hart, so the concept of the law. More recently, Scott Shapiro with his book Legality, that he's able to take on board the genuine insights of legal positivists, that there is this stuff called human law. It comes out of social sources. What law is and whether it's sound are two separate questions in our legal system. He's able to take on board those insights while still retaining the insights of the natural law tradition, which is that what we just said about the source and separability isn't the sum of all law. And the natural law tradition gives us answers to why we should follow positive human law. So it's a really complicated topic, and I've tried to give what I think are the key points, which is what is natural law, and what's natural law's perspective on the legal system, and how is it different from the kind of leading rival, which is legal positivism.
Before we move on to the real kind of challenge to originalism, you talk in your book about this, and I think this is kind of a key concept, the idea of specification and determinatio. Do you mind explaining to the audience kind of what those are? Because that's a real kind of point of interaction between the natural law and the positive law in your construction of it.
Yeah, so I think that's actually one of the, I'm really glad you picked that out, because I think that's one of the key insights that natural law originalists have identified and leveraged in their justification for originalism within the natural law tradition. But to be able to explain why it's such a key insight, let me back up just one step and talk about what it is that that insight is responding to or is able to respond to. And so one of the criticisms of folks who are sympathetic to one, remember I said there are kind of two reasons why I'm investigating originalism. One is I'm an American, so I want to follow the Constitution. I'm also a natural lawyer, so I want to follow the natural law. And there are folks over here who are natural lawyers or legal scholars generally who are natural law philosophers, but who reject originalism. And I want to describe why they do that, and then why the insight that you pointed to, Connor, is a response to their criticism. So here's the criticism as I understand it. So there are folks who believe in the natural law, things that I had said earlier, and they have two basic criticisms of originalism. One I would describe as methodological, which is what you were describing response to, and the second is substantive. I think it's actually more minor. So here's the methodological point. The methodological point by these natural law critics of originalism is that if one believes in natural law, then one should expect, I think, justice, and from their perspective, justice would require that officers in the legal system employ the natural law in their official duties. So that would mean, for example, that people in Congress would decide whether to pass a statute utilizing natural law. The president would decide whether and how to execute the law utilizing natural law. And courts would decide whether and how to enforce laws utilizing the natural law. And that's where that last part is where most of the controversy is at. So these scholars would say, these critics would say that in the identification of the Constitution's meaning, in the application of the Constitution's meaning, and then whether to follow the Constitution's meaning is all, the officials should always employ natural law in those three different steps. And that's definitely inconsistent with how originalists understand originalism. And because originalists understand originalism as having two key commitments, one commitment is the fixation thesis, which is that the Constitution's original meaning was fixed when it was ratified. Second was the original meaning thesis, which is that fixed meaning is the public meaning of the text when it was ratified. And then the third, I mentioned two, now there's three, is the constraint principle, which is that officials today should follow the fixed original public meaning. And that is a very positivist way of looking at law. It's saying that we've got these positive legal materials. The Constitution came out of the Philadelphia Convention. It was ratified by the state ratification conventions. It exists only because of what these human beings did from these social sources. And so the natural law critics are saying that this understanding of constitutional interpretation put forward by originalists is blind to the importance of natural law that it should play in our legal system. So let's go back to your point, Connor. So how do natural lawyers respond to that? These natural law originalists respond to that. They leverage this key point that you mentioned earlier, this idea of specification and determinatio. So when you think about natural law, there are relatively abstract norms that everybody agrees on, such as do good and avoid evil, respect innocent human life. But then when it comes to actually implementing those natural law norms in ways that humans can live together in peace, reasonable people are going to reasonably disagree about them. And the classic example, it's a little bit hackneyed, but I think it does the work, is regarding highway regulations. So at least in modern society, you need to have effective highway regulations in order for people in the United States to be able to live together in relative peace. And think of all the choices that have to be made in order for those highway regulations to be effective. It has to be, sides of the road, speed limits, safety regulations, car regulations, seatbelt regulations, child seat regulations, and on and on and on. And the natural law doesn't tell you an answer to any of those questions. So right or left side of the road, 55 versus 60 miles an hour. But in order for people in that political community to live together in relative peace, to pursue the common good, there have to be answers to all of those questions. And the way to think about how those answers come about is from the concept of determinatio. The common concept of determinatio is reason governed, reason guided, but not reason determined. So we should have highway regulations. There are clearly bad answers, 0 miles per hour, 1,000 miles per hour, but within a really broad range, there are reason guided, but not reason determined outcomes. And so this concept of determinatio is crucial to the natural law originalist account of the originalist interpretation of our Constitution, because what these folks argue, including myself, is we argue that one of the determinatio of every legal system is who gets to apply the natural law and when, if at all, they get to apply the natural law. Now, some legal systems, you probably covered some of them, Connor. So think about England, the English common law system. So at least in the early versions, I'm not an expert on the English common law system, but this is my impression of it. At least in the early times of the English common law system, before you had a lot of cases and cases reported that would identify what the legal norms were, the judges were more directly and more frequently accessing natural law to determine the outcomes of particular cases. Or maybe for those of us who are familiar with the Old Testament, King Solomon did a lot of ruling, and he wasn't relying on pre-existing legal norms. He was ruling based on his own judgment about what justice required in particular instances, or even with the decrees that the King Solomon had issued. That's one way to run a legal system, right? One way to run a legal system is to let your legal officials on a regular basis appeal to and apply natural law. But our legal system, the originalist claim, made a different determinatio. We limited which officers can and when they can use natural law. So for example, I think it's the case that if a person's in Congress and they're deciding whether, for example, to allow interstate competition for healthcare insurance, I think they can appeal to the common good, to distributive justice, and to other natural law federalism. Now, I guess that'd be subsidiary to be the natural law version of that. They can appeal to those natural law norms to decide whether to pass a statute or not. But now when it comes to judges, here's the originalist claim. Judges, the originalist claim, are infrequently able, or they're infrequently authorized by their office to appeal to the natural law. And in fact, in the focal case, and what judges are supposed to be doing, what are judges supposed to be doing? Identifying and applying the law. And in those situations where the original meaning is determinate, there's no role for natural law interpretation. That's the core originalist claim. And that claim is built on that point that you had made of a determinatio. It's a determinatio of our legal system that judges in a restricted way get to appeal infrequently to natural law. So when do they get to appeal to natural law? Different scholars have different points. I'll just give you two examples. So one is sometimes the Constitution's original meaning itself appeals to natural law. I think my view is that the original meaning of cruel requires that punishments be proportionate to the crime or not disproportionate to the crime. That's an appeal to justice. Second, when the Constitution's original meaning is indeterminate, that is, it doesn't give one right answer to a legal question, some scholars, including myself, have argued that legal officials can appeal to natural law about how to construct or create constitutional meaning within the bounds of that underdetermined original meaning. So the last point I would say, Connor, would be, why would a legal system like ours choose to limit judges when they use natural law, right? So like the natural law scholar's perspective would be, hey, if a judge is facing an unjust law, why would you have the judge enforce that unjust law? It seems obvious that the judge should not enforce the unjust law. And different scholars give different arguments. So I think a great paper by Jeff Pojanowski and Kevin Walsh argued for a series of what scholars call second order reasons. In other words, reasons that aren't a reason for action in one's, that are not primary reasons for action, but are systemically secondary reasons for action, i.e. the rule of law would be an example. That these scholars have argued that originalism is a way to preserve the rule of law by limiting judges' access to natural law norms directly. I think the reason, let's say that we were James Madison and company, when I look around at the United States in 1787, 1789, and I'm thinking of the office of judge, one of the things that I think of is that the United States in 1787 was already a pluralistic country. It's become even more so, of course, over time. And one reasonable response to pluralism is to try and make as much law as possible up front. In other words, people know what the legal rules are up front, so that way the legal officials who are doing the interpreting, i.e. judges, aren't in the process of interpretation constructing constitutional meaning based on contested concepts of natural law. So my point is that our legal system, I think has really good reasons to limit judges to not using natural law in most instances. All right, so back to you, Connor.
Yeah, absolutely. I mean, so I'm going to push a little bit on this. One of the things that you said in your remarks there is that when the law is clear, the meaning is clear on something, that's what the law is, and then the judge has nothing further to do. And I believe some of the critics on the other side of this are saying, wait a minute, Marbury versus Madison, right? If you see a statute that is inconsistent with some other source of law, we don't close our eyes to that other source of law. And the concept of right, the natural law is applicable to all people at all times and all places. And this is more of the kind of higher law constitutionalism thing, more of the Blackstonian approach, where you say you might have a statute law that's above a regulation, and above that's the Constitution, but above that is the natural law. And in the instance, say, of a statute that's very clearly violative of the natural law, no matter what kind of determination, that's outside of those wide bounds, say a law that denies the right of self-defense after you've retreated to the wall in your own home. What reason would a judge close their eyes to this other law, as opposed to, I guess, what Chief Justice Marshall said, which is that it's emphatically the province of the judiciary to say what the law is.
Yeah, I think that's an extraordinary question, and I think it supports my point. And I'll make two moves to do it. So first, thinking back to Marbury versus Madison, which I love teaching that case. I spent an entire class session on it because it's such an important case. And when you think about Marshall's argument, one of the premises of his argument for why he, as a Supreme Court justice, could not enforce the 1789 Judiciary Act was his claim that it was part of his judicial duty. So over and over in his opinion, he refers to judicial duty. What's judicial duty? Now, judicial duty varies by legal system, right? So the judicial duty of a French civil law judge is going to be different than an English common law judge, right? These different legal systems are going to have different, going back to my earlier phrase, determinatio about the scope of the judge's office. And Marshall's claim was that in the American legal system, in Article 3, the scope of his legal authority was to identify under the U.S. Constitution what was the supreme law of the land. And there were basically three options: the Constitution, federal statutes made in pursuance thereof, and treaties. And so, if anything, and there was in that order, right? That the Constitution was the highest of those legal authorities. So Marshall's claim is that the scope of his office, the authority that he was given, which was not necessary, right? Because different legal systems do it differently, required him to not close his eyes to the Constitution, but to follow the Constitution if there was an inconsistent federal statute. Now, so using that same line of argument, what the original scholars have argued is that part of the scope of judicial authority of federal judges, and I think state judges might be different, so I'm going to put those off to the side, is that federal judges, they do the law, absent some circumstances like constitutional construction I had mentioned earlier. And when you look at just contemporary evidence for that proposition, you can look at, for example, the debates in the Federalist Papers. So one of the arguments by Brutus in the Anti-Federalist Papers was that, oh my gosh, these federal judges, they're going to be using equitable power, they're going to be misinterpreting laws, they're going to be doing all kinds of nefarious things. And Hamilton's response in Federal 78 was very similar to Marshall's argument, which was, whoa, Brutus, you're going way overboard here. that the federal judges are going to be limited to interpreting and following the posited human law. And he never once said that, in fact, he pushed against the claim that federal judges would be using other sources of law, it's a higher law, natural law. And so the contemporary debates, I think, reflect the proposition that the understanding of the scope of the office of judge in 1789, which comes from, I'll mention Blackstone in a second, which comes from the Anglo-American heritage as well, was to limit the judges to identifying the hierarchy of human-made law and then applying the highest law in that hierarchy. And Blackstone, you had mentioned as well, Connor, which I appreciate. So Blackstone lived in an English system where you had, he clearly was somebody who believed in natural law. He clearly was somebody who at the same time believed that the highest law in his jurisdiction was a statute passed by Parliament. So he's an example that our framers and ratifiers had that had both a consistent belief in natural law, but also at the same time that within the legal system, the highest legal norm, at least for judges, was the positive law of that jurisdiction. So I think that the practice at the time, and even Marshall's reasoning, supports the kind of narrow perspective on the office of judge that I'm describing here.
Very good. That's a very able answer to I hope was a tough but friendly
It was
question.
a great question.
That's how we like to do them
that
here.
one coming.
So you've referenced this some with some of the kind of the second order reasons why a judge would want to follow that. So would you mind kind of outlining what are the arguments the natural law originalists really make to explain and justify originalism in the face of some of these criticisms, if you can really package it tightly?
Yeah. So one response is that the natural law critics misunderstand the natural law tradition's view of positive law, right? So positive law, this was our earlier conversation, positive law plays a crucial role in the natural law tradition's view about how human communities flourish, that we need positive law to make determinate what was otherwise indeterminate, which side of the road to drive on, what the speed limit's going to be. So the first response is, hey, you guys just aren't getting how law operates, how positive law operates. It's essential role. It's creative role, actually. I think it's kind of interesting. So the natural law critics tend to be kind of from my right, so to speak, but other critics tend to be from the left, and they actually think of the natural law arguments for originalism as being kind of theistic and kind of, oh, what's the right word? Kind of like have religious overtones. I think it's the opposite, right? So the natural law tradition is saying that human creativity plays such an important role in identifying the positive law and applying the positive law of a political community that humans actually are elevated in the natural law tradition to being lawmakers, like the core lawmakers in the jurisdiction. Okay, so a little bit of an aside. So the second response that the natural law originalists have given is, well, why would you do originalism from the natural law perspective? And there are three basic arguments that have been given so far. So the natural law originalists that have been writing so far include Professor Joel Alicia, who's at CUA. He has a great paper from Notre Dame Law Review, maybe 2 years ago now. And what he did was, I actually didn't think it was possible, but he had revived and rearticulated an argument from popular sovereignty. It's really sophisticated, it's really nuanced, and I'm not going to do justice, but let me just give kind of a very short summary of it, which is that in the natural law tradition, that the original political authority of a people in a political community has to be delegated in order for it to be effective, so that way the legal system can secure the common good. And his claim is that in our legal system, that what Americans had decided was that we would delegate to the framers and ratifiers the authority to identify and approve the original Constitution, our Constitution of the United States. And then his third move is, and to make that delegation, to make that decision by the framers and ratifiers effective, interpreters and officers today need to follow its original meaning. So that's the LSA argument, very short and very tight. As I mentioned earlier, Pojanowski and Walsh have another argument, and the argument is effectively that since Americans disagree, because of our pluralism, about many first order questions, what is justice, what should religious liberty be, how broad should free speech be, and I think that's just patently indisputable, right? Those are true propositions. Their argument is that in a diverse and pluralistic political community, we have sound second order reasons, i.e., we need to get along to follow the Constitution's original meaning. And so it's not that they're appealing to justice, but they're appealing to, we need to have a set of rules of the road. And actually, the rules of the road, as I said earlier, can actually be, they could be different, right? We could have the French conception of judges, or we could have we could get rid of the Fourth Amendment and put in some different protection for privacy. Maybe like the Justice Douglas Griswold versus Connecticut conception of privacy. But the point is that because of the rule of law, we need to have settled points of coordination, and originalism provides that. My own argument, what I call the law as coordination argument for originalism, is similar. It says that the goal of a political community is the common good. To secure the common good, you need to have a legal authority that identifies the legal norms that the humans in that political community are going to follow. And there's a lot of indeterminacy, which is why you have determinatio and creativity. And the key point in my move is that to make the authoritative, prudential, coordinating decisions by the American framers and ratifiers effective, we need to follow the meaning that they were utilizing, which was the, I argue, original public meaning of the text. And so there's two responses by originalists. One response is, hey, you guys just don't get how positive law works in the natural law tradition. Second, and following the original meaning leads to the rule of law. It leads to effectuation of popular sovereignty. It leads to the common good. Are the reasons that we gave there.
So somebody listening might just say, well, you've just called yourself a natural lawyer, but you're just saying just do originalism. Is the natural law even like necessary for originalism, or is it just some kind of ancillary thing, like some garnish that you like to put on your scholarship?
Yeah, that's it's kind of a tough question. And here's why. It's not that I don't think there's an answer to it. It's just so think about this as an analogy. So let's say that a person watching us was a religious person. They believed in a faith tradition. They were Methodist, they were Baptist, they were Jewish, whatever it might be. And part of that faith tradition is about how to live life well, right? So I have a faith tradition, and one of the reasons among many why I follow it is that I think it helps me understand how to live my life, my kids' life, my family's life, the best it can be to have full, happy lives. But there are obviously a lot of people who don't follow my faith tradition or the Methodist faith tradition or whatever it might be. And so a person from that perspective could be asked the same question by you. Hey, if you think Methodism is right, then how do you account for these folks over there who seem to be doing who don't believe in Methodism, but seem to be doing okay? I think that person could say two things, right? One would be, well, they might actually live better, happier if they follow my faith tradition. But number two, I think what most religious people argue is that the reason why, this is a really fundamental point, the reason why they're able to do what they're doing so well, why they're able to live well, is that even without knowing it, they're actually following God's injunctions, right? So whatever that religious tradition's view is of God and what those injunctions are. So there's a deep way in which when a person doesn't know what they're doing consciously, not following Methodism or Baptists or Judaism, but they're still actually following God's laws and God's rules to help them live full lives. I think something similar goes on in the debates about originalism. So I think a person can be a darn good originalist without being a natural lawyer. In fact, I've seen it done. And so you might say, well, how can that be? And I think it's in an analogous way, right? Which is that what the originalist person is doing without knowing it is actually following the natural law tradition's injunctions, right? So I had mentioned earlier this idea about determinatio, that our Constitution's original meaning is our legal system's way of identifying rules of the road, so to speak, that are coordination points for all Americans to follow. And in a pluralistic country, that's really important. And if somebody who's doing originalism is actually participating in that creative enterprise of identifying and following those points of coordination through determinatio, even if they don't know that that's actually a part of the natural law tradition, right? So there's a way in which I can see originalism being done without natural law, and I can see it being done really well. But then at the same time, just as a religious person might say, hey, that person's living a good life, but their life would be even fuller if they followed my religious tradition. A person could say, they're doing originalism really well, but there actually are some ways in which they would do it better or with a more fulsome understanding if they use the natural law tradition. And I'll give you just two examples. So one example would be, there are some parts of the Constitution that I'm confident require resort to natural law. I gave the example of cruel earlier. So to do natural law effectively, you'd have to have a concept of justice, and you'd have to be able to apply it in cases to find out if the punishments are just or unjust. And if you don't believe in natural law, I suppose you could still do it. You might say, you have to say, if I believed in natural law, what would I think justice meant? So I think there is a way to do it, but actually from a deep natural law perspective, that's not good enough, right? Because if you've read Aristotle, you know that justice not only is a proposition about relations between beings, it's actually a virtue that human beings have. And so if one doesn't believe in the virtue of justice, then it's going to be harder for that person to practice the virtue of justice. So there's a really deep way in which knowledge of natural law will help you do originalism better in those places. There's not that many, I don't think, but in those places where the original meaning incorporates natural law norms. Second, I had mentioned earlier about one of the values added of the natural law perspective of law, because it explains the point of law. Why do we do it? Same thing with originalism. So I think that one of the virtues of the natural law originalist perspective is that it gives answers to the question of why are we doing this particular tradition. And I gave the example earlier of we doing it because it secures the common good of the United States. So that's a long way of saying I think you can do originalism without natural law and do it really well. But I think that the fullest, best explanation for our Constitution, including originalism, is a natural law one.
Since
You
we
want
are
to take,
talking, yeah,
you want
go
to
ahead.
take one of the questions, Connor?
Yeah, no. So we've got some questions from the audience here. One that seems to be on specificity, basically. So is the natural law is it so specific in what it requires that it determines kind of what body of law is necessary to be enacted in terms of, is it specific enough to really be an instruction to the legislature? Like when you write a law, it needs to look like this.
Yeah. So that's a great question. And I'll be a little bit cagey and then give a direct answer. So I had mentioned earlier in my introduction that the natural law tradition, at least in the West, is multifarious. There's lots of different perspectives on it. And there are some aspects of the natural law tradition. I'm thinking of people here like Hugo Grotius, Samuel Pufendorf, who purport to identify relatively detailed norms that they claim are specifications, an earlier point that you had made, specifications of the natural law. I'm honestly skeptical of that claim. I think, going back to my earlier point, I think a lot of the work that a legal system does is it's a good faith implementation of the natural law through these creative determinatio. I forget the Latin plural, but multiple determinatio. And so going back now directly to Mr. Forsyth's question, I think the answer is there are very few. There are really important, but relatively few in relative terms in the scheme of things, specific injunctions of the natural law. And so what that means is most of the work is being done through the creative human process, employing prudence and justice and other natural law norms to identify what the positive law norms are going to be for cooperation in our political community. But let me add one more thing. So I like to use the analogy of parenting. So I'm a parent, right? And so I've got kids, and when I'm working with my kids, I can do two things, right? I can state what the rule is. So treat your mother with respect might be a rule. It's a good rule. But then I can also identify the point. Why is it good to treat your mother with respect? Well, one is that justice requires it, right? So you should treat your parent with respect. But number two, it also helps you be a happier, fuller human being when you give people what they're due. And so that is the point, right? Is the idea. And so natural law not only provides some specific rules, but it also provides the point of a political community. So one point of the political community is making sure that people have justice, distributive and commutative. Another point is that human life is respected. So there are natural ends that the legal system has to pursue. And so the natural law doesn't provide a lot of detailed rules, but it does provide ends that provide guidance for the human lawmakers when they're creating their legal system. There's I think a follow-up related question as well, Connor, if we could do that.
It's more of a specification of the first one, but
Okay.
I have more questions. So let's keep plowing through.
Yep.
So our system seems to have, certainly our constitutional Bill of Rights, all of that does a pretty good job protecting natural rights, and certainly our founders were very big protectors and believers in natural rights. So it might be that conflict between our positive law and natural law has been kind of at a minimum because of, we live in a relatively just society, but and the theory that you've been kind of describing here seems quite unobjectionable, and yet we're here because there are big critics. So where do they see originalism as coming short in our current system, which by and large does a pretty good job?
Yeah, I think that natural law critics of originalism see originalism coming short in the methodological point that I had mentioned earlier, that, hey, you originalist folks are misunderstanding that officers should be using natural law in the identification, application, and decision whether to follow law. We've talked about that earlier, so let me put that off to the side. I think they also think that originalism fails because it leads to substantive results that are inconsistent with the natural law. Now, which results are inconsistent depends on which scholar we're talking about. So, for example, let's say it may be a more right of center scholar might say that originalism fails because, well, let's take the example of the Dobbs case, Dobbs versus Jackson Women's Health, right? It dealt with whether there's a constitutional right to abortion. And some scholars, Hadley-Arkes is the person who comes to mind, have argued that the majority opinion by Justice Alito messed up, right? What the majority opinion should have done is it should have appealed to the natural law proposition, which I believe in, that unborn human beings are human beings. Human beings should not be licensed by a just legal system to take away the life of other human beings, i.e. abortion. And the conclusion should have been, in Justice Alito's opinion, this alternative opinion should have been that the Constitution prohibits abortion. And so that's one example. On the flip side, so maybe somebody from a different perspective, maybe more left of center, might conclude that the Dobbs opinion got it 180 degrees wrong. That not only is there not no constitutional right to abortion, there's actually there is a constitutional right to abortion. And how would he know that? Because of the justice that is due to women in their role as individuals, in their roles in society. And so you have critics from different perspectives who claim that the actual propositions that are the product of the interpretation of the original meaning end up being inadequate in some way. And for what it's worth, I actually think that, I think that the original meaning of the Constitution is not perfect. There are some areas where I think there are significant gaps. There are some areas that I think are deeply imprudent. Just one example, when Article 3 was adopted and federal judges had lifetime tenure, with the average lifespan, et cetera, you could imagine how lifetime tenure might be prudent. It ain't, my view is it ain't prudent today. And so that would be a situation where there's something that's deeply imprudent, maybe unjust, but deeply imprudent in our legal system that we're locked into with the original meaning until we change it, which is going to be hard. Although I actually think there's a political consensus on that particular point. And so a natural law critic might say, why are you living with these imprudent and unjust original meaning norms? And I actually think that phenomenon of the original meaning actually being unjust or at least imprudent in many, I wouldn't say most, but in many, certainly some, in maybe many instances, is evidence that originalism is doing law, right? So going back to what I described earlier, what is the point of law in the legal system? It's to identify especially in our pluralistic political community, what are the rules by which Americans of different viewpoints are going to live together in relative peace? What that means is sometimes the rules are going to be ones that we're going to agree with and we're going to disagree with, right? And it also means, here's the second point, that there's a way in which the legal system identifies ways to change the legal propositions. And both of those, both what the norms are and how you change them, are determinatio of the legal system. And so one has good reasons to follow these determinatio because the legal system, if it's basically just in a pluralistic political community, is allowing us, so if our viewers think that America is reasonably just, which I think it is, it's allowing us to live in reasonable peace together. That's a sound reason to continue to follow a legal system that overall is just, but it may have particular propositions that are unjust.
All right, and you referenced Hadley-Arkes earlier, so I'm going to bring him up again. He calls
Sure.
himself the originalist's originalist. He
Okay.
points to lots of the evidence that the founders, they read Blackstone. They understood and recognized the natural law that was out there. And his proposition, certainly in his more recent book, Mere Natural Law, is that these things were kind of incorporated by reference or didn't even need to be said to be understood as part of kind of the nature of law. So
Okay.
if you're committed to originalism, how do you deal with that kind of claim that, well, the most original originalist will also incorporate natural law, at least in some places?
Yep. So I thank you for raising that, and I'm glad you did. So I think Professor Arkes and I agree on one of the premises that you articulate that I think is one of his premises as well, which is that the framers and ratifiers believed in natural law. There's a great book by Stuart Banner called The Decline of Natural Law. So if people want to read about what he does is he talks about here were how things were in the early republic, and then we moved away from natural law. But his premise is we were believing in natural law in the early republic. And then also Cody Cooper and Justin Dyer have a book, The Classical Christian Origins of American Politics, which talks about the both religious and non-theistic sources of natural law belief in the early republic. So I think so those two books I think are strong evidence among many others of the proposition that the framers and ratifiers believed in natural law. But if you believe, which was my argument earlier, that part of the natural law tradition is that the natural law norms themselves can't guide most if human conduct, which side of the road to drive on, what the speed limit should be, and that instead one of the goals of the legal system is to posit positive human law to make determinate these otherwise indeterminate areas, then it follows that people who believe in natural law, like James Madison, could create a legal system that one of the points of which was to not authorize all officers in all situations to resort to natural law. So if you believe in the process, for the point of determinatio, then the framers ratifiers' choice to not let, for example, federal judges to use natural law on a regular basis makes perfect sense. It's just one of the determinatio that they made. And then there's a related point that you had made, Connor, about Professor Arcus talking about the framers ratifiers would want the interpreters to incorporate natural law, right? That the Constitution was incorporating by reference natural law norms. I've acknowledged, I think that's true in some situations, right? So I think the Eighth Amendment cruel is an example of that. I actually think, and this is maybe a little more controversial, that the word person in the 14th Amendment means those human beings who in fact those beings who in fact are human beings, and unborn human beings are in fact human beings. And so I actually think that's another example of an incorporation to what I would call a natural kind, right? So the kind of being that is a species, a member of the species Homo sapiens, a rational animal, as Aristotle would say. So I agree with him that there actually are situations like that, but where we disagree, and actually I think the burden would be on Professor Arcus, would be wouldn't we need evidence from our legal system that federal judges or other officers are authorized to rely on natural law norms beyond situations where the public meaning of the Constitution also referenced and incorporated and used those natural law norms? Because my argument was, and this, I had references to Federalist 78, I had references to the debates between Brutus and Publius to support my empirical claim that in fact the office of federal judge in Article 3 did not include on a regular basis resort to natural law, and that instead it was limited. Now, it's unlimited in other areas, right? So I think maybe Professor Arcus and I would agree on this point, and the natural lawyers would agree with this point. In the scope of Article 1 power that federal legislators have at natural law, and in the president's discretion about whether and how to execute the federal law, use natural law. So I think those are propositions. I think there's a deep reason why James Madison's choice, as I'm describing it, to limit federal judge use of natural law is sound, while allowing legislator and executive use of natural law on a regular basis is sound. And it goes back to an article that John Finnis wrote, where he describes, when you think about what it is that judges are doing in the focal case, and what it is that judges do when they're doing judging, and what legislators do when they're doing legislating, the core goal of a legislature is to change the law, right? So if the law is X, we've got a problem, let's change it to Y. But the core goal, and really what you're learning, Connor, as a law student, your goal is to identify what the law is and apply it to a case, right? And so the real value, the real skill that judges have is they identify pre-existing law. And you're going to law school, Connor, and you probably are more knowledgeable about natural law than most law students. But law school and legal training and legal practice really don't train people to identify natural law norms. And so my point is that there's a really sound reason for James Madison's treatment of judges different from legislators, different from executives, which is that it's appropriate in changing the law to resort to natural law norms, because you want to figure out how to reach those natural ends that I identified earlier. But when identifying what the law is, absent situations of indeterminacy, I mentioned that earlier, that it's not appropriate, it's actually not helpful to identify what the law is, because the law is what is posited in 1789, 1791, et cetera.
Very good. I have a specific question that might be helpful. We have a pretty strong unenumerated rights tradition. You see this in, right, firstly, like in our substantive due process and our Ninth Amendment stuff in state courts, and that's something that you had put to the side earlier, but it also comes up in human rights discourse and international law, the law of nations. is there any room for natural law, in your view, about the unenumerated rights, which are kind of by definition underdetermined? And kind of in a similar vein, when interpreting those things, should there be some kind of rule of natural law avoidance, like we have a constitutional avoidance question? And should we be interpreting things, if not generating things on our own, so as not to contravene the natural law? Those are
Yeah.
kind of more specific questions, but I'd love to hear what you have to think about that and how maybe state courts might be different in this
Yeah.
space.
So let me say a couple things about your idea about unenumerated natural rights. So it's clearly the case that Americans, since the Declaration, believe in natural rights. And in my previous discussion, it's clear that in this conception, the legislature and the executive, they can take on board the belief in natural rights and implement it in their official duties, right? There's no doubt about that. But if what I said earlier was right, which is that judges are limited to identifying the existing determinate law, then in order to enforce unenumerated natural rights, a judge would have to have a legal hook, would have to have a proposition in the Constitution that says incorporate and follow unenumerated natural rights. And there's a debate among scholars. I would say there are kind of two common clauses that are identified by scholars to support that. So one is the Ninth Amendment, and I think the book to read is a book by Randy Barnett, maybe 25 years ago now, called "Retained by the People." So it's a collection of essays about claiming that the Ninth Amendment is a textual warrant for federal judges to identify unenumerated rights. And then the Privileges or Immunities Clause in the 14th Amendment is also, by some scholars, a locus of authority. So again, both of these are from my perspective, are judges authorized, what are judges authorized to do? Identify the existing law. And the Ninth Amendment would be a source of existing law for unenumerated rights. And the same thing with the Privileges or Immunities Clause. When it comes to a rule of construction, it's interesting. So I think it's plausible. I just don't know if there's any scholarship on this point. I think it's plausible, Connor, that there might be a rule of construction, given the founders' perspective on natural law. There might be a rule of construction to interpret constitutional provisions, maybe. I'm not saying there is, but I'm just saying I can imagine that being the case in light of the natural law. Interpret it broadly if it's a rights protecting provision, interpret it narrowly if it's a government power provision. I could imagine that being the case, right? But in order for it to be the case, here's my direct answer to your question. In order for there to be a rule of construction, it would have to be one that judges are legally authorized to use. And I would need some warrant in our legal system. It could be the text of the Constitution, it could be the structure of the Constitution, but there's got to be something somewhere for them to be able to do it. Because otherwise, it goes against what I said earlier, which is that I think the office of judge is constrained and can only in certain modest instances utilize natural law.
All right. Well, thank you for entertaining all those extra questions. I've been
Those are great.
holding these questions for so many people, and so many people don't have great answers. So I'm very glad. So
I hope
we're
you feel
really
good.
pushing it on time because I'm just so glad to be able to host you here. So are there any other questions or issues that you think we should be addressed before we wrap?
Yeah. I would just say that I think that for our audience, reading the critics. So I think reading Mere Natural Law that you mentioned by Professor Arcus would be an example. I think reading Common Good Constitutionalism by Professor Vermeule would be worthwhile for our audience. And then I think reading the scholarship by Professor Lisea, Professors Pochanowski and Walsh, and myself would be kind of, if you read those bodies of scholarship, then I think you've got a good feel and you can make your own informed judgment about which perspective on the relationship between natural law and originalism is the right one.
Alrighty, well, thank you for coming and so much for being so generous for your time. Thank you to everybody watching for your time and really engaging with this, what can be quite obscure thing. Professor Strang has really done an able job with it. So I hope you all found it quite fruitful and interesting. This is a second to last one. Next week will be our final challenge, the final boss in the challenges to originalism. That'll be hosted by the University of Virginia School of Law student chapter over there, and that's going to be on whether living constitutionalism is superior to originalism. So with that, we're going to call it a wrap. Thank you again so much for coming, and have a good night.
Thanks, Connor.